Good evening, guys. This side Rahul Magan here is a Group Chief Executive Officer, Treasury Consulting. As we speak, Treasury Consulting is a multi-asset and multinational hedge fund. By multi-asset, I mean we actively take positions in multiple asset class of the globe. And by multinational, I mean we covering our positions in United States, Europe, and Asia Pacific region. But like I repeated many a times, and I would continue to repeat, that we are a proprietary hedge fund. By proprietary, I mean to say no third party. I repeat, no third party can invest capital in our funds. Today, I would like to highlight something which I did notice in Indian Penal Code 354, Section 354. Shortly, you can say women molestation. I'm not saying that the women molestation is not happening. It is happening, but unfortunately, now it is a weapon which is being used by women towards the man. And these all are not my wordings, these all are the wordings of respective honorable courts on time to time basis. I have the documentation with me. This documentation is by Delhi High Court. This documentation is by the National Crime Records Bureau. This is by Supreme Court, who clearly said that Section 498A is increasingly being misused to settle personal scores against husband and his relatives. This is a document by Honorable Allahabad High Court, which clearly saying that every matrimonial case exaggerated wants to curb misuse of Anti-Dowry Act. It's once again a document by Delhi High Court, which is clearly saying courts can impose fines for false and frivolous cases filed to divorce the other party to withdraw the complaints. This is again by Honorable Delhi High Court, which clearly saying Delhi High Court expressed worries over alarming increase of fake rape cases. This is a document by Delhi Commission and Delhi Commission of Women, which saying between April 2013 to July 2014, around 1 year, 2 months, you can say 53.2%, 53.2% of the rape cases registered were falsified. This is by Delhi Commission of Women. This is a document on the Malimath Committee, which was formed, and this is false dowry case charged, false dowry charge grounds for divorce, a ruling by Honorable Supreme Court. I have these documents, I have more documents, and these documents are coming on a periodic basis, which I continue to download from the internet. And today I would like to highlight a very important thing in IPC 354, which is Ex-Parte court procedure. And I would like to link this with one of the documents I downloaded from the internet, which covers Ex-Parte decree provisions with Code of Civil Procedure. I would like to link both of them. But before that, I would like to express my gratitude, my thanks to the honorable courts for acknowledging a very gruesome fact that these laws are misused, that to alarming level. Guys, this is the document which I downloaded from internet. As you completely aware that on time to time basis, I continue to download the documents from the internet. I study them, make my notes, and then I make a video. You can easily see that I highlighted using my pens and I make the notes also in these documents. I already explained the ex parte in my earlier video, but here in this I will explain the ex parte in a very limited tone. An ex parte decree is a decree passed against a defendant in absentia, which means that the plaintiff filed a case, the court, because of some reasons, not been able to have defendant into the case, and henceforth this case is ex parte. We need to understand one thing very clear, that there are various rulings which we have as far as the ex parte is concerned, as far as the code of civil procedure is concerned. And there are various reliefs also which are granted by Honorable Supreme Court as far as the ex parte decree is concerned. I may not be able to cover all reliefs, but I would be focusing on the fourth category, which is called fraud, which means suit on fraudulent grounds. Suit on fraudulent grounds. But before that, let me first make a case for you. We all understand that 498A, 406 oblique 34, 354, 354A, B, C, D, 506, and various sections who are designed to protect the women, they are extensively being misused. And unfortunately, the husband and his family are facing lot of mental issues, lot of litigation issues, lots of mess and stress in a world which is already full of stress. And if I look at the recent statement made up by the Honorable Delhi High Court as of 27th September 2022, which is published by a website owned by Mr. Shoni Kapoor, this is saying that it is remarkable, righteous, refreshing, and rejuvenating to learn that while ruling explicitly and efficiently that time has come to initiate action against person who file frivolous cases, complaints under section 354 A, B, C, D, IPC, etc. for an ulterior purpose. It is a national tragedy. Please use a word, see the word. It's a very heavy word. It's a national tragedy that the laws meant to protect of women are fast turning into weapons of stabbing men in most cowardly, dastardly, and gruesome manner. Words are very heavy. Now, let me make a case for you. Suppose a woman misusing 498A and 406 and assume that the brother-in-law of the husband is a rich person, and willingly or unwillingly he is unmarried. The woman writes an email to police about file of first information report covering 354A. But police refused to file FIR because police feels that proper evidences are not there to file the FIR. Henceforth, they disregard the application made up by the woman. The woman views 156.3 and reach to the court regarding the file of the FIR. The courts proceed with ex parte litigation, which means the plaintiff is woman, the defendant would definitely be her brother in law. Her brother in law is completely unaware about what is going behind the scene. He is completely unaware about that. On a single day, he received a notice from the woman, saying that this 156.3 is initiated and now the court is going ahead with 354A. Now, my first question is that can courts go with ex parte transaction in a criminal case when the second party is not invited to speak, not invited to put his facts before the honorable court? That's the very important point, the question which I would like to raise. Secondly, only because a woman is saying XYZ thing happens with her, can 354A be initiated against a man? And especially when the honorable courts on time to time basis are giving judgments on the cruelty and the misuse of the law. In fact, today, which is 5th November, last week, two more judgments came into the picture, and I am going to be downloading both, would be making a separate video. It takes another weeks or so because time is limited. Now, I would like to link this with the ex parte decree, which is Code of Civil Procedure. Under Code of Civil Procedure and relief against the ex parte, and especially point number 4. A regular suit can be instituted against an ex parte decree allegedly obtained by fraudulent means. To maintain such action, it should be proved that the fraud alleged must be actual, positive fraud, a meditated and intentional contrivance to keep the parties and the court in dark to obtain a degree by that contrivance, which means that Court of Civil Procedure CPC is clearly saying that in case an ex parte decree somehow being received, even in this eventuality we can invoke under the fraud category. Please listen carefully. The suit is maintainable despite unsuccessful application made under Rule 13, Order 9, or the rejection of the application for an appeal. The very important thing which we need to learn is that 354A can harm the reputation of a man. It can easily damage the integrity, the respect, and the designation of a man who not did that. My basic questions are, without having any evidence in the place, without having proper and actual documentary evidence in the place, can we have ex parte as far as the section 354 is concerned? That is the most important point which I would like to highlight. Because if this is possible, in this eventuality, the role of defendant, which would definitely be the brother-in-law in most of the cases, he would be the actual sufferer in this case. Because his point, his opinion, the facts are not on the table. Number one, in the law process, it takes many years, probably more than that, to explain him his thoughts. In this eventuality, he might be suffering from legal expenses, the mental tension, the stress, the blemish on his dignity, and many more things. I once again would like to supplement my thoughts with the observation made by the Honorable Delhi High Court. And I once again would like to thank you, Delhi High Court, for making such commendable observations, as always. The bench observed in para number 7 that unfortunately it is now becoming a trend to register FIR alleging offences under section 354 A, B, C, D IPC to either force a party from withdrawing a complaint instituted against them or to arm twist a party. Arm twist, which is a very heavy word actually. Offences under section 354 A, B, C, D IPC are serious offences. Such allegations have the impact of tarnishing the image of a person against whom such allegations are made. Tarnishing the image of a person. Please do take a note of that. Allegations regarding these offences cannot be made at a drop of an hat. This practice is an abuse of the process of law. And I completely agree with the honorable courts in that regards. Now, let me, made one conclusion, the conclusion made by the court. While what the learned judge, Justice Subramaniam Prasad Sir of the Delhi High Court has held, it's best suited in the present circumstances, but it is a high time and now the penal law must be amended suitably. A woman under no circumstances should be allowed to get away lightly after leveling the most serious allegation which tarnished the reputation and dignity of a man to the hilt, and in many cases he is made to suffer imprisonment in the fake cases. The Honorable Court also giving a reference that we saw most recently in Vishnu Tiwari case where he had to suffer without committing any offense for 20 years. 20 years, which means around 15-20% of the age of a man, right? 20 years of incarceration in connection with the false rape case filed against him by a woman owing to an alleged land dispute in a Lalitpur district in UP and was recently acquitted. Now, my question is that can a woman only to settle her scores, file 354A towards her brother-in-law only because her brother-in-law is a rich person, and because to protect his dignity, because to protect his image, common sense, her brother-in-law would love to, love to resolve this. Can this be allowed in a system? That's the more important point when the honorable courts on time to time basis are giving a red flag or warning signals. That is the most important point. Secondly is this, which I would like to highlight, which is the Civil Procedure Code himself is saying that suit on the fraudulent grounds. My point of submission in this, and I would like to request my point of submission in the following way. First of all, we have to make sure I would like to request honorable courts that in any circumstances, the woman who is filing fake 498A, 406 oblique 34, 505, 354, A, B, C, D should not be allowed to relieve easily. Because the mental tension, the legal cost, and the physical pain and the family atmosphere the person is facing is beyond any words. Beyond any words. In today's environment, when the outside and the global economic situations are very stressful already, such fake and false allegation can even mentally torture a person to any extent. Any extent. And secondly, I would like to request the Honorable Court and Judiciary that, like Singapore, we should have a system. Singapore, if you break the red light willingly or unwillingly, there is no police person who is standing. Automatically, camera will take your photo and you get this photo on your contact details and you supposed to pay whatever $50, $100, depends upon the charge. And if you do not pay, the police will impound your vehicle straight. Similarly, if we have a procedure in a CPC, in this eventuality, this procedure should be made automatic, which means as soon as the cases are found frivolous, cases are found false, cases are found manipulative, cases are found to arm twist, automatically the suit on fraudulent grounds should be activated. And I have a sufficient evidence to prove that, to prove my point. According to National Crime Records Bureau, NCRB, out of 4.66 lakh cases, approximately, at the start of 2023, only 7,258 convicted, 38,165 acquitted, and 8218 were withdrawn. It means the conviction rate is merely 15.6%. Sir, please think about the mental pain, stress, tension, the hyper, I would say the pain the family has to bear in courts, waiting for the courts, hearings, legal expenses, and whatnot. That's my humble request. And especially when we have a procedure in a code of civil procedure that you can file a suit on fraudulent grounds. It means that we have a mechanism there. We just need to use that mechanism in a better way, which would help the natural justice. This is my humble request to the judiciary. And it would definitely be benefit for millions of people who are facing this burden. Our YouTube channel would continue to bring the facts, the knowledge, the important issues in legal structure, the matters which are subject to interpretation issue, everything in public. But I once again thank you very, very much to the honorable courts that they started highlighting a very, very serious and gruesome thing which is happening in our system. Thank you. This is Rahul Magan. Have a great time ahead.